Hello, everybody. Welcome to Live from the Table, the official podcast for the world famous Comedy Cellar. I am the producer of the show. My name is Periel. I'm here with the owner of the world famous Comedy Cellar, Noam Dwarman. His co-host, comic Dan Natterman, is somewhere at sea in the Caribbean. And we are joined by a very special guest from the Cato Institute, policy scholar, Mr. Walter Olson, who is a senior fellow and is known for his writing on law, public policy, and regulation. His first book, The Litigation Explosion, was one of the most widely discussed general audience book on law of its time. And it led the Washington Post to dub him a, quote, intellectual guru of tort reform, close quote. Although I was advised to mention that he is not, in fact, an attorney, though he often seems to get mistaken for one.
I just criticized them.
Welcome, sir. Actually, before we get into the...
How was that?
That's very excellent, Perry. Before we get into the current events, this is fascinating. I'm hearing it for the first time. How does someone who never went to law school become a qualified and teach themselves enough to feel that they can criticize lawyers?
Well, they couldn't really stop me, could they?
Can you turn them up? Good.
Oh, sorry. Is this better?
No, it's on our end. I think he'll turn you up. Go ahead.
Okay,
Don't worry about it.
Well, as I said, they couldn't really stop me. I was trained in economics originally, and I think the proof of it is that lawyers are my best fans. I've written 4 books at this point and hear back a tremendous amount from lawyers. And when I keep hearing, yes, this is how it is in my practice, a smile spreads across my face. I did the research. Not too badly, though.
Yeah, well, I mean, you wrote about tort reform, is that right?
That was my first couple of books, yeah. And since then, I've spread out to writing about problems with the legal system more generally, and there are a lot of them. And so I've had a chance to write about criminal law and constitutional law and a lot of other areas like that. So it's not just business law anymore.
I mean, as a business owner, we fantasize about tort reform because it terrorizes us, and you have customers and employees walking around with visions of being a plaintiff in their minds at this point. What I know you'll probably know what I'm going to refer to, but one of my favorite columns ever written was by George McGovern for young people who once ran for president. And after he left the Senate, he opened like a bed and breakfast inn or something like that. And he wrote a column in the Wall Street Journal, and he went bankrupt. And he wrote a column in the Wall Street Journal saying essentially, if I had known then what I know now, I would have never voted for all these laws. Sometimes when somebody trips and falls, they just tripped and fell. It's not anybody's fault. Do you know that column?
I remember that column well, and and you learn afterward. And if you follow his career path, the numbers have to add up, which they don't on Capitol Hill, unfortunately, but they do if you're running a business.
Yeah.
No, I'll tell a story of my own, which is my first book did so well that I wound up getting on the Oprah show, and it was really something. But I found out afterwards, she was this very friendly interviewer, very, very good interviewer, but also very friendly. I found out afterward that she gets sued constantly.
Yeah, of course.
And so she does have that perspective of someone who has seen both sides.
Yeah, I mean, sometime off the air, I would tell you, and really, I've had nothing compared to some of the other people I know, the stories that they've had. But I can tell you one quick story, just because so my father, workman's compensation, for people who don't know, is supposed to be a bar for employees suing the employer. So if you work as a cook and you cut your finger off, you get compensated through workman's compensation program, and you're not supposed to sue your boss. So this is years ago when I was a child. Part of the job of the people in the kitchen was to take the greasy stuff out, to throw it out. And my father, and I can remember it like it was yesterday, used to constantly tell them, wear your rubber-soled shoes, wear your rubber-soled shoes. He wasn't just on top of this. He was obsessed with it because he didn't want them to trip and fall. And not just because he would get sued, but because they become complacent about the risks of it. And he would do it all the time. So sure enough, one of the cooks tripped and fell, and he broke his thumb. And the end of the story is he was able to sue my father. No, he wasn't able to sue my father. His wife was able to sue my father for loss of consortium
Oh,
because he hurt his thumb. The pain of his thumb interfered with his ability to get an erection,
and
and his
I
wife was
wasn't
able
going
to
to go
sue
there as far as
successfully.
how the thumb related to the consortium, but
Yep.
it's and the courts differ a lot from state to state on how on whether they'll entertain that kind of thing or throw it out, and that is one of the reasons why workers' comp rates encourage people to move, unfortunately, from some states to others. New York is very bad. A lot of businesses move to states like North Carolina, where the judges just ride herd on it more, trying to make sure that only the high merit cases get through, and so everyone's insurance and everyone's workers' comp is lower, and businesses move there. It is no getting around it.
Yeah, I know a bar owner, one of the biggest bar owners, maybe in the country, who told me he'll never open another bar in New York for just the death by 1,000 cuts of all the various little disadvantages. Anyway, so let's get to the Trump thing. So let me the first Trump thing I want to talk about. And I actually don't know which side of this issue you're on, but I would like to talk about the Trump. The real estate case or the fraud case where he fraudulently valued his properties. Now, as a threshold issue, to me, is the politicization of the justice system, of the legal system. And I just want to set it up with two things that came to mind. When Trump ran for president in 2016, one of the ugliest things he had ever done, one of the ugliest things he did, was to say that if he became president, he would instruct his Justice Department to go after Hillary Clinton on the email case. And there was an editorial in the Times by Stephen Levitsky, the guy who wrote the book about threats to democracy. And this was one of his prime examples of how Trump would be a threat to democracy. He would politicize law. And then I have another example here that just came to mind as I was in the car, which I think is really interesting. When Trump had that call with Zelensky that he was impeached for, one of the things he said, I just looked it up. That's why I was rushing in here, Max. He says to Zelensky, this is in regard to with regard to investigating Hunter Biden. Mr. Giuliani is a highly respected man. He was the mayor of New York City, a great mayor. I would like him to call you. I will ask him to call you along with the attorney general. Meaning he was going to have Bill Barr call Zelensky to see what they could turn up on Hunter Biden. Now, fast forward. Go ahead. You want to cut in there?
Well, yeah, there was a line from that same conversation that really sticks with me, which is that he told Zelensky, "We don't need to have you find Biden guilty of anything. It's the investigation we want," which just, and so often the process is the punishment. I mean, I come back to that line an awful lot because if you can get the process going against someone, you have already dealt them an injury and maybe a reputational injury that they can't recover from.
Right. So left, anti-Trump people, right and left, rightfully so, were sickened by this. I am too. And then we have a woman who runs for Attorney General of New York State, and she says, as the next Attorney General of his state, I will shine a bright light into every dark corner of his real estate dealings and every dealing, demanding truthfulness in every term. So she runs for office on the promise to get Trump. And she's lauded. She's a hero. We love this woman. Okay, so let's start there. What do you want to say about that?
Right. Well, and you have started with the single thing that gets me angriest on Trump's behalf about the politicization, because my wider argument is that in order to evaluate, his claim that it's all lawfare and it's all political and it's all because he's Trump, you've got to look at whether the cases are meritorious. If he really did do the crime or misconduct, then that's one thing. If he didn't do it and they just cobbled up the case anyway, that's totally different. But either way, whether she's got a meritorious case or not, Letitia James should never have campaigned that way. It destroys people's confidence that they are going to get the impartial justice that we should be demanding from an elected prosecutor and everyone else, for that matter, elected or otherwise. So she herself dealt the worst blow to the credibility of her prosecution. That having been said, as we go on in the show, we'll look at the merits of, where she might be right and where she might be wrong. But yeah, she stepped in it there, and I never want to see another prosecutor do that if I can help it.
Well, let's stop there for a second. Is it enough that it's a meritorious case? I mean, if she had said, if I become Attorney General, I'm going to go after real estate fraud, that would be one thing. But the idea that, what if she said, if I were Attorney General, I promise never to look too hard into, black people. The meritorious case. I think there's. I mean, what if Trump had a meritorious case against Hillary Clinton? What if Barr found a meritorious case against Hunter Biden?
Okay, fair enough. I didn't say it was the only thing to look at. I did say that it was kind of the biggest thing that you had to look at some point, is how meritorious the case was. And I will freely say, there are situations, for example, where every car is speeding down the boulevard and they wait and stop until they get the person who ran against the mayor and only stop them for speeding when they let everyone go by. Yeah, you can find cases where even though the substance, the charges have substance, something still went very wrong. That having been said, as a defense in a court of law, that usually won't work.
Right.
You might, the judge will not throw out the case based on you let all these other people go. So just bear that in mind as we talk about Trump's woes.
No, of course, that's not fair. But I just like to, because I can't unravel it from politics and also from what's best for our country, right? So one of the I analogize a lot of things to my experience running a business, and one of the things that I've dealt with many times is a manager who has it in for a particular employee in a personal way, and then they start to look for reasons to, maybe to and I don't let this happen, by the way, but they start looking for causes, and they will want to punish somebody for a particular role, and so they might that no one else gets punished for. And I say, but they did give that customer the drink. I said, I know that, but don't tell me the reason you're punishing them is because they did that. You're looking for a reason to punish them, and it undermines our entire morale here. No one's going to respect us as bosses if they see that in a heartbeat. Go ahead.
No, and from case to case, and we'll be talking about, there may be 6 different cases we'll be talking about, and it differs. I myself think that one of the wrong turns we took on the road was in having prosecutors run for office by campaigning. Mm-hmm. That does not lead down a good road. They pick unpopular people. They pick people they think their audience gets angry at, and they say they're going to go after them, and you'll never see the number of prosecutions they're going to file. Well, that's bad enough to start. And then, of course, Letitia James, and I think Alvin Bragg in New York, the state's attorney in Manhattan, did some of that campaigning too, although not as bad as James did. So yeah, as we get to the different individual cases, you always want to look at that and bear in mind, is the prosecution seeming to strain or stretch? Are they leaning over backward to be more punitive in what they demand or throw in more theories they wouldn't have used against another defendant? Valid thing to look at.
All right. Now the next step is my kind of taking it step by step, is that for people who don't know about this is a very unusual aspect of law. This is a civil case. It's not a criminal case, so it doesn't require proof by reasonable doubt. And can you tell us, if you know, how did the government get into the practice of bringing civil cases like this? What problem were they trying to solve? Because normally, so people know, if you've been damaged, you can sue civilly whoever damaged you. So somewhere in this, and I don't know this history, it seems to imply that the government was going to step in because the people who would normally sue for themselves in some way were not up to it, were disadvantaged, couldn't be expected to serve their own interests.
Let me try to condense 100 years of history
Yeah.
into 25 seconds.
Yeah.
First, we want to look at New York because New York has special, very pro-prosecutor rules that are at issue in a couple of these cases, but especially the one we're talking about right now. So the first question to ask is, why did New York get out way in front of other states in giving prosecutors the right, just right off the bat, to sue for fraud without having to prove reliance and damages, which are two classic elements that you would have to prove if you sued someone for fraud on a one-on-one basis. And so if you go back to that, New York has several of these laws, and they all kind of interrelate to create a toolkit for someone in Letitia James' position or Alvin Bragg's position or whatever. And so New York's philosophy, and I'm going to try to put myself in their shoes and give a positive account of what they were trying to do. They said, we want to clean up New York's market. New York is the most important financial market in the country, and at that time was the most important commercial market in a dozen other ways. And they said, we want to make it second to none in how clean it is. And that means rather than just wait until someone loses money to fraud, we want to actively patrol the marketplace. When we see someone committing a pattern and practice of fraud, not just a one-off, but doing it a whole bunch, we need the right to shut them down from those activities before they actually victimize someone. This is the affirmative case for why New York passed these laws decades ago. And now those who write from a more civil libertarian point of view, and I count myself in that, want to get a whistle at this point and say, wait a minute, you are putting an awful lot of power in the hands of the government. Maybe they will use it for good most of the time, but what happens if they decide to settle scores with it? What happens if the evidence on which they're acting is not actually very good and someone gives them a bad tip and the person didn't violate the law? What's going to happen to them when you have given these very powerful tools and also these very high penalties that they can invoke, penalties that can, and let me pick one out from the case about Trump's business practices and lying to the banks and so forth. They did so-called forfeiture. Now, forfeiture is not unknown in regular law, but it's what happens in forfeiture is that if you did something based on dishonest premises, they can come and take all the money that you made from it, even though you may have spent a vast amount of time, actually doing stuff. So, Washington Hotel that Trump owned, apparently he lied to the banks quite a bit to get the financing for that. He sells it after 5 years, makes a lot of money because obviously a bunch of things went well for him other than the bank believing his lies. Obviously there was some creativity or some positive things that the Trump organization must have done there. So the judge comes in and says, no, under the concept of disgorgement, you have to disgorge all the money you made by lying to the bank. Now that's really harsh. The example I give as an analogy is, suppose you lied in order to get a college diploma, and then 30 years later your earnings were much higher throughout your life. Are you going to have to disgorge all that money that you got by lying once, or is there going to be some more middle of the road thing where you might have to give some, but not all? So for various reasons, the New York prosecutors are armed with the potential for very high fines and penalties. And all this adds up. This has gone on for 20 years or more. If people remember the name Elliot Spitzer, the name Eric Schneiderman, these were big national names. They were considered at the time to be the most important adversaries of the business community in the entire country. No one in Washington was as menacing to business as the New York Attorney General. So the powers have been there for a long time, and the powers have been used in questionable ways, unfortunately, for a long time too.
So, but the intended victim, the victim that is intended to be defended here, is when they conceived of these fraud laws, was I would think the consumers who are being defrauded.
They will usually described these laws as being meant to protect consumers. If you clean up the market and drive all the fraudsters out of state, the ones who benefit most, they say, will be the little guys, even if the fraud that you caught them in is lying to Deutsche Bank or some other big entity.
I mean, normally it's the banks who are doing the fraudulent practice here, and the little guy with their credit cards or whatever it is that is getting taken, right?
There are a bunch of very strict laws against lying to banks. A lot of them are federal laws that are not at stake here, but one of the things that I think, it's fun to talk about, but ultimately it's a side issue, is why didn't the banks complain? So far he's paid off the loans, although some of them are still outstanding. And with the
let me stop you.
Insurance policy,
let me stop you there. Let me just so people understand. And maybe it's time to bring in the case. Trump overvalued. Why don't you give a nutshell of the case now? Because there's some people are going to understand the stuff you're saying. Go ahead.
Yeah. Every time Trump borrowed money from banks, he just lied his head off. And, there are some famous instances where he multiplied the square footage of his triplex in Trump Tower threefold, making it out to be 30,000 feet instead of 10,000 feet. But he did the same thing on a whole bunch of other things, Scottish golf courses. And there was one where he valued rent-controlled apartments as the landlord, as if he was free to sell them for full market value, which anyone who's lived in New York knows, is wildly off. It's like 80 or 90% off of what the actual value might be. So he was lying and lying and lying. And so the Judge Engoron, accepted expert testimony saying that this was the underlying reason he was able to get favorable financing, and sometimes why he was able to get financing at all for various real estate deals, which meant that all the value of those things was potentially at risk.
Okay, so let me stop you there, because this is the part I have to call bullshit on it from my own experience and from common sense, which is that I just recently was dealing with a bank about a loan, and hold on to your hat here. They did not take my word for anything. Okay, I told them that my building here was used more than 50% for commercial use. They came in with tape measures, measured the stairwell. This is for a small loan. There was nothing I said that they would believe. I'll tell you another thing you won't believe. They asked me what my finances were, and I said, well, I could just tell you. And they said, well, can you send us a document? I said, you don't need the documents. I'll just tell you. No. We want to see your tax returns and your books.
Let me take the other side on this, because legally, it's not actually a good defense to say they should have done more due diligence.
That's not what I'm saying. That's not what I'm saying. I'm saying they went into this eyes wide open.
I have no doubt that for a regular customer, they do that sort of thing. In the case of Trump, the court went through a bunch of reasons why the equities are not very much on Trump's side on this. One of them is his is a privately held company. That is a family company, which means that an awful lot of stuff that other big businesses would have to disclose because of shareholders and the like, they can keep completely private.
Like what? Like what? I can't keep anything private. I'm privately held.
No, there's lots of financial stuff about the flows of money within the corporations that companies with shareholders have to disclose for SEC reasons.
Yeah, but what kind of business? You know what? I'd love the advice. What can I keep a secret from the bank or from the other? I've never heard of anything.
Depends on how you negotiate with them. But beyond that, the bank, when it comes to people like you, the bank has other ways of checking. They have other ways of checking.
But let's just not get off that early point, because I've heard this argument made, and one of the reasons I wanted someone, I said, well, what is it that Trump was able to keep secret that they could not have insisted on seeing? And by the way, what is it that he did keep secret? Nothing.
Okay. Well, a couple things. First, in several important stages, he would let the person who was checking the records into a room. They were not allowed to take or keep any records. They were allowed to look at things for a few hours and then had to leave. Now, of course, that's all part of the negotiation. It indicates that he was keeping some information very close to the chest. My favorite example, and I brought up insurance because I think this is, it was part of the substance of the case that he lied to his insurance companies to get better, to appear a better risk than he really was. So, directors and officers insurance, all organizations practically have to have it to defend their directors and officers. So he was buying directors and officers insurance, and they asked standard kind of question, which is, do you have any reason to know that your company is about to be engulfed in litigation? Are there any investigations, or are there any pending notices you've been put on? And according to the testimony in the case, the insurance company was told, nope, nothing of the sort. Well, almost immediately after they underwrote the policy, in comes these claims for them to pay out money based on I think it was the Trump Foundation scandal, that particular one. At any rate, so big claims. They, I don't know whether they rolled their eyes or what. They said that when we renewed the policy, we asked for 5 times the original premium. Now that we realized what the actual risk factors were, and implicitly gave an 80% discount because of the lie about we're not facing any pending litigation. Now, at some point, I don't even know how you ask someone to prove that they're not facing any litigation, because are they supposed to show you every email they've ever received? I mean, it's just not practical not to take the word of a lot of people in that situation.
No,
so anyway, that's my mini case.
It's a crazy question because, as you know, probably better than anybody on earth, people are sued all the time. You're always in the middle of some incident which might metastasize into a lawsuit. And who is going to tell the insurance company, yes, I think I'm going to be sued? So the insurance company can then say, okay, well, if that happens, we're not going to insure you for that.
I don't suggest lying to insurance companies about this, because you have the alternative of saying, yeah, there's this matter that we consider a small matter. We've dealt with this kind of thing before. We think your exposure is not very great. And, tell the truth and then get the resulting premium. Right? But it does seem to me, and maybe I've just led a saint-like life over my years, but, I've never lied to banks and insurance companies the way Trump just could not let 15 minutes go by without lying. The scale of this, was it V.I. Lenin who said that at some point quantity becomes its own quality? I mean, Trump's quantity of lying at some point does become its own quality.
Yeah, I don't want to defend Trump lying. I don't want to defend being a liar. But I will say this, with intimate knowledge of these systems, especially insurance, the system is set up such that if there is anybody being totally honest, they can't survive in business. And the companies, for instance, like if you get an audit from an insurance company, they will often say we want these records or pay us 20% premium, meaning they know the game. It's all, everybody's in on the game. And my suspicion with the banks, now you tell me if I'm wrong, is that because they are so regulated in terms of how much risk they are allowed to take because of all the trouble they've gotten this country into in the past by taking too much risk, they are happy for the client, the borrower, to exaggerate a little bit. Then they can, with a wink of an eye, accept the exaggeration. And then they're allowed to make a loan and get themselves around the regulations that they wouldn't ordinarily be able to make.
Well,
they wanted to make this loan, right? They wanted to make the loan. Let's go there. How could they not know? First of all, okay, I'm jumping around, but as I understand it, they wanted to Trump said Mar-a-Lago was worth a couple $100 million or something. The state wanted to value it at $25 million or $27 million. Now, this is an insane valuation. I would pay $27 million. I'm sure I could find it for Mar-a-Lago tomorrow.
You know that it's restricted by deed covenant to be used only as a private club.
Well, okay. No, I don't know. I know that, but I want to dispose of that right now.
Okay.
Well,
that was the core of the fraud there.
right,
Anyway,
but this is decisions made by people who I don't understand. Everybody who I've done it, I've seen an opportunity that had some legal regulation or zoning or something that I thought I could get around. So I was ready to pay more for it than other people were. And there were plenty of people ready to do it because I would then put more money in to change the nature of this opportunity and make the big score. Now, the idea that Trump made a deal with Florida to have a certain tax rate in return for him keeping it as a private club. Now, this, to me, is the flimsiest of all deals because if the private club goes out of business, Trump says, I'm bankrupt, then Florida then has to change the deal because they can't have a piece of property which just gets abandoned because no one's going to put a private club there,
well,
they can't
could. And
they can't order
restrictions.
They can't order somebody to operate a private club. So
no, however, they can crack down if they try to use it for any other purpose.
But they wouldn't. They would say. I mean, I had to tell the town I'd plant 30 trees in order to get my swimming pool.
I'm glad my money is not at stake because I would not lend it based on the hypothetical higher value. If you could get the laws changed in your favor, I would lend based on the actual current economic value.
Okay, but I looked.
Then I'm not a bank. No one
right.
has asked me to be a bank.
Okay, but I look. Let me put this in. I was looking in just about the valuation of Mar-a-Lago. In Forbes magazine estimated the value of the estate at $350 million. Another magazine, another newspaper said real estate experts outside of Palm Beach guessed the place was worth more than $200 million. Someone else $725 million. These are all experts. Some Palm Beach luxury real estate agents have told the Associated Press the property would sell for $300 million, maybe $600 million. A bidding war could bring it up to $1 billion. These are all people who are aware of this deed. Now, it doesn't matter. It doesn't matter to the bank whether or not they could even succeed in changing the deed. It matters that they had no reason to think that a few people wouldn't take the risk.
Okay, I don't know enough about Mar-a-Lago to keep on disputing that particular case. I will go back and respond to a couple of points you made earlier, though, which I think are important. One is, can't banks simply send off the risk to some other holder of debt and free themselves from any of the default risk? And the answer, I think, generally is no, they have to keep some skin in the game by keeping some exposure to default risk themselves. That's the way it's set up in order to keep them on the ball about not taking horrendously bad risks. Now, it kind of fell apart during the 2000s, but that's the way it generally works. Secondly, you mentioned regulation, and I think you're on the right track, although in a different way than you were arguing, which is that all of these relationships, I am convinced, have an element of a bank trying to keep happy someone that they know perfectly well, is a leading political figure whose goodwill is potentially going to be tremendously important if they get into some sort of regulatory issue in which they need a favor done or hope to get a merciful treatment.
Wasn't this before he was in politics? Wasn't this before he was in politics? Wasn't this before Trump was in politics?
Trump, some of this was before, but I'm thinking in particular of the argument, why didn't the banks complain in recent years? Now, in recent years, when these issues came up and people said, I don't see a bank complaining, I think that's my answer to why you don't see a bank complaining, is the bank desperately wants the relationship to work. All the more so now that the man has served 4 years as president and might become president again. Of course the bank wants the relationship to work. Of course, the bank is not sending experts to give the worst possible version, if it can help it, of how he treated things. Again, to retreat to the way New York lawmakers conceived of this, they would have swept all this aside and said, we are trying to clean up the market. It's not a good market if the amount of lying is as material as we've just described in the last 10 minutes. Let's do something to give prosecutors the power to clean up that market.
Right, but the way to clean up the market would be to go after the banks to insist that they do their due diligence.
Prosecute the banks for making loans that were where they were lied to? I don't see how that works.
Yeah, in other words, I don't know banking regulation. I am sure there must be some regulation that requires the bank to take good faith actions to verify that what they're getting is.
They understand that that's a matter of business judgment and that it's going to vary a lot from situation to situation. What kinds of diligence make sense depends on how well they know the person, depends on a lot, what information is independently available about the business or the property. No, I mean there are wider things saying that banks cannot squander their assets in such a way as to leave their policyholders unable to redeem their accounts and all that. But there is not a law against long shot loans.
Here's an interesting question. I don't know the answer to this. Do you think the banking industry in general, was happy to see Trump pay through the nose, or unhappy to see this decision go that way? My gut tells me the banking industry doesn't see this supposedly purported decision in there to protect them. I tend to think the bank's like, you know what? Don't help us. We're fine without you. I don't think the banks think this is good for them.
Again, to reiterate, the point of the law is not to help the banks, but there was a lot of reaction in the New York business community. And I think, to switch back to the line of argument I was taking, which is that these are dangerous powers that prosecutors have. Mm-hmm. And we have seen them use them for political reasons. We've also seen them use them against companies that were not guilty of anything. That's not this case, but it is other cases where they, made companies spend tens of millions of dollars defending themselves, and the companies had done nothing wrong. Business is very afraid of activist New York attorneys general, and they are very afraid that one of them, who has just scored a big political victory, is going to get more funding and 100 more lawyers in her office, and before long, a lot of their businesses are going to be targeted. That's a reasonable thing for them to worry about. I don't blame them.
Now, I'll tell you that when I hear that Trump, said the apartment was 30,000 feet and it was only 10,000 feet, at that point, I'm like, you know what? No matter what else I think, they can't just sign off on that. That's an obvious misstatement. I don't know that the penalty should be hundreds of millions of dollars, but I'm not offended by the notion that some penalty would be paid for that. But this valuation thing is, listen, I just bought a building. It's public record. I bought it for $7 million. I asked professionals at the time I was bidding on it what it was worth. And when I say professionals, I mean seasoned professionals in the New York real estate business. And the answers I got varied by about 200% from people who do this every day. And I had people telling me that if I paid $11 million for it, it wouldn't be too much. And I had other people telling me I shouldn't pay more than $4 million. This is so offensive to me, that somebody will pretend that there is a value to a property that is known as that can be compared to measuring the square footage of an apartment. This is a lie.
And I have to say, part of what you say is right. If there weren't those variations in evaluation, the art market would be impossible as we know it. I mean, that's how the art market works, and there are not many prosecutions in the art market, even if the dealer is sweet talking you into saying the painting is worth 3 times what it really is. But on the other hand, in this area, it is not all made up. It is not all completely subjective. As the judge said, it shocked the conscience as it laid on one after another of the types of, judges deal with expert witness testimony all the time. And believe me, in expert witness testimony, exactly the same stuff goes on, in which someone says, oh, the damages were, 3 times, and the other one hired by the other side says, no, the damages were only 1/3 of the times. Judges accept that there is a range of reasonable opinion, but they also don't like it when someone comes in and just tries to completely pull the wool over their eyes, or extending it to the papers filed in these cases when they try to do it in the business world generally.
All right, it shocks the conscience, and again, it's like, I don't want to be arguing for a liar, but but much of the significant lie here in terms of actual having financial consequences was the Mar-a-Lago thing. So they take and that shocks the conscience to me. The notion that a property that I believe the property has a view of both sides of Florida, the Atlantic and the Gulf. Yeah.
If you were free to build, it would be an extremely valuable property. There is no doubt.
The notion that a property like that would only be worth $25 million when apartments in Manhattan are worth $25 million, and that the judge knows that, and despite the fact that non-interested articles have been written about real estate brokers saying that it's worth hundreds of millions of dollars, this just doesn't hold up.
I'm no Mar-a-Lago expert. I know that Florida is a lot cheaper than Manhattan as markets go, but we had a point in which I think we actually can agree in a pretty harmonious way, which is the thing that Trump's best argument here is that the numbers are way excessive. That if he had done all those same things and had been hit with a much, much lower financial penalty, I would see that as rough justice. I think that the numbers that Engoron came out with are way high compared with what I would have done as the judge. I think that's Trump's best chance on appeal is to figure out an argument to get the numbers knocked down. But let me, just because I keep switching back and forth to make sure we see the arguments, one of the reasons Trump did so badly on that is that Engoron concluded that not just to the banks, not just to the insurance companies, but during the litigation, Trump lied in depositions and things, and so did all of his executives. And when you do that, you take a risk, which is first judges get mad, and we can argue about the extent to which Engoron should have set aside his feelings of being mad and all the nasty stuff Trump had said about him on social media.
There's no argument.
A judge should set all that aside.
He's supposed to set it. He's supposed to say he takes an oath to set it aside.
Right. But aside from that, what judges do not take an oath to do is to not let a series of lies during the litigation affect their weighting of credibility. And so this hurt Trump very badly on things like the testimony of expert witnesses about the financial impact, the disgorgement and so forth, because Engoron wrote saying basically there were a number of points where really you could have gone with Trump or with the opposing witness, and I chose to discount Trump's credibility to zero because of all these other laws, and so I'm going to credit the opposing witness.
Right. Now, can I stop you there, because this is a little much, because when it came to Michael Cohen, the judge said, I know that Michael Cohen is a convicted liar, and I know that he hates Trump deeply, but you know what? Not all liars never tell the truth. And he said, the judge writes, Michael Cohen told the truth. Now, now I know how much Michael Cohen hates Trump. So what I'm seeing there is a judge who, by fiat, is saying, listen, you're a liar, so I'm mad at you. You're a liar, but you didn't lie to me. So I believe there's good in you after all. And this is not this. I don't see any justice here whatsoever.
Okay, I will, up to a point, defend the judge on this. He is totally entitled to weigh the testimony of someone who has clearly lied in the past. And he is also, in my view, entitled to take into account lies during his own case.
No.
He's entitled to weight those more heavily.
Sir.
I subvert the very process that he is trying to achieve justice in.
Right, but I don't.
There's nothing wrong about his taking those into account.
No, but correct me if I'm wrong. You seem to be implying that because he was angered by the lies, I mean, he didn't charge Trump with perjury or contempt of court, that led to a harsher decision. Now that's not supposed to.
Anger was the wrong word. I will say that it led, by the judge's own account, he said that because of all these lies that were proven during our legal proceedings in our case, I am going to not give Trump the benefit of the brakes on the instances where there really is an insoluble conflict of testimony. I'm going to go with the person who testified, Trump. I don't see that as being reversed on appeal. I don't see that as being judicial misconduct.
No, I don't see it being reversed on appeal, because he's the trier of fact, and they're going to defer to the trier of fact, the judge.
Well, no, but on appeal, they could look and see whether the judge acted in a prejudiced way, whether his handling of evidence and evaluation of facts was. Appeals courts can review some of that stuff. I just don't think they're going to reverse him in this particular case. I mean, we'll see. At some point, we'll find out.
Well, the whole thing. really bothers me. I found what I had one more. Or two more things. So correct me if I'm wrong. One of the theories here was that because I think the spread was 4 points, because Trump got an interest rate 4 points less than he would have without a personal guarantee. This is the amount of money that he essentially robbed the bank of, and then because he had that extra cash essentially in his pocket, then he was able to make another deal that he wouldn't otherwise have had the money to make. And then he sold that. Now we're going to get all the. This is this amount. Let me just get through it. This amount of fortune telling, knowing that if this didn't happen, we assume you would have taken the 8% interest. We assume you would have not found another way to get the other deal. We assume that if it went wrong, you wouldn't have found a partner to come in to, like, assumption upon assumption upon assumption. That we know, we can tell you that if not for this thing, you would have been out you would have had $300 and something million less in your pocket. This is nonsense. Don't we all know this is nonsense? Nobody knows that.
Let me say, first, in general, I agree. And that's why when we got back and I talked about disgorgement and talked about the numbers being too high, basically because I agree with what you just said. Yeah. Now, to switch over to what, wait,
like I said, no,
did the judge misapply the law? Unfortunately, the underlying law just is very weird. And the underlying law allows this kind of thing to go on, which I think is good reason to go back and fix the law so that it stops doing that. But Trump is not the first, nor is he the 100th, to have this sort of speculative disgorgement theories, like a Lego set, sort of piling up to unstable heights. Trump encountered the law, he took the law as he found it, which is very hostile to defendants. And I think he's right to see that this is disproportionate. That's not because the judge was violating the law. It's because the law the judge was given to apply is, I think, a law that is not well rooted in good legal principles. I think, so that's, the complaint is generally right, but it should be lodged against New York's lawmakers, really.
Yeah. What would you say? What does your gut tell you? The odds that this would have ever happened to anybody who was not hated like Trump?
You can never get into someone's mind and know for sure. So I'll say that right off the bat. On the other hand, someone whose scandals had gotten into the newspapers as much as Trump's had, whether it be the Trump University, the Trump Foundation, remember that it wasn't Letitia James's lawyers who broke the story about the square footage of the triplex. That was it Forbes? It was some private business reporter. And so when all of those little explosions are going on of indicating that a business enterprise might be fraudulent, it would attract the notice of even a kind of slowpoke attorney's office. Now, the New York Attorney's Office, the New York Attorney General's office has people who do nothing but go through the newspapers looking for news stories that might indicate that they. So,
Mr.
once
Olson,
again,
can I say this?
Yeah.
When you have, like, if Trump told the bank one whopper and the bank didn't catch it, say, oh, Trump put one over on the bank. When you tell the bank 20 easily verifiable whoppers, and the bank, which gave me a full proctological exam, when the bank doesn't think they're lending a lot of money, when the bank doesn't undertake the due diligence to look at harder, take a magnifying glass to any of these whoppers, isn't that a very overwhelming prima facie case that the bank was in on it, and that the villain here is the bank? Because the danger to us is that the banking system is unstable, not that they give a sweetheart loan.
read Judge Aguiron's opinion, because there was expert witness testimony on these various points. There was a parade of people who talked about what the bank knew, what it could have known with more questions.
Well, they're not going to admit to it.
The testimony, and again, maybe he shouldn't have credited the testimony, but the testimony was there against the general narrative that you just laid out.
So I was also looking into this controversy about the Chauvin case, and Dr. Michael Baden was one of the people who testified for the prosecution against Derek Chauvin. I was looking into Dr. Michael Baden. He was the guy who said that OJ could not have killed Ron Goldman and Nicole Brown Simpson because, based on his expert testimony, there wasn't time for OJ to have done this and get back to, based on the coagulation or whatever. OJ had to be innocent because there simply wasn't time for him to. He could not have committed the crime. Now, we all know OJ committed the crime, which is to say that everybody hires their experts, and the experts say what they need to say.
And judges need to listen to and invoke that testimony. Now, it's funny, we haven't gotten onto this point, but one of the possibilities on this case and virtually all of the others is that Trump didn't have the most competent lawyers in the world who did not develop the counter expert testimony, did not object at the right times to possibly get objections they could preserve. Trump has gotten himself into, half of the trouble, it seems, is through hiring lawyers who aren't as good as they should. The other half is through the stuff that comes out of his own mouth, because very often it winds up being used against him. So yeah, some of that expert testimony stuff, we'll never know if he had a really sharp lawyer developing the best counter expert testimony, where they might have gone with that. I do know is what he got, which was a bunch of expert testimony that was very damning on these issues of due diligence by the bank and so forth. It didn't back up the idea that the bank was at fault.
So two things. There's nothing you could tell me, I would stake my family's life on it, that if the bank took his word for the size of his apartment, that that proves to me they couldn't care less about the size of his apartment. If they really cared about the size of his apartment, they would have measured it. I understand they just can't, there has to be certain repercussions, but I live in the real world. I just know how the real world works. I know how my limited experience with banks. There's no way that this is public record. They go in there. One thing he could pull over on them. They're friends. They want to get him the loan. They hook him up. This is what you need to. Hey, Donald, you need to show us this amount for us to be able to sign off on the loan. I need 40,000 votes. You need to show us this amount. It's the same kind of thing. This is what I need. You understand what I'm saying? And he shows them. Okay, the apartment's 30,000 feet.
Let's say you're right, and let's say that a bank that knew that it was going to put off 95% of the risk of default on this loan is going to find some other, dummy financial institution that was very unsophisticated and throw off 95% of the risk by passing on all of the bogus paperwork about the assets. Because remember that all of these loans have to have covenants of percentage of value, so they're all backed up and would be in default if the numbers were. Suppose the bank were totally in on it and were helping its friend do a favor by conspiring with him in a fraud against a third dumb financial institution. Don't you see that leaves him completely liable under the New York law? He has committed the frauds. Even if the bank were at his side, even if the bank were cheering him on, he's still committed the frauds, except now we have pointed to a different and more likely victim, which is whoever wound up holding the bag among third-party financial institutions as the bank got sold off.
I'm of the opinion that our legal system is such that if someone is hated and a prosecutor runs for office on promising to get them, they can interpret the law, and if they have a judge who hates him too, to elicit a penalty such that no one ever conceived of before. People who kill people drunk on the road and get sued for wrongful death get a few $1 million.
let me
Yeah.
revert to my long career writing about tort law, in
Yeah.
which things like a scratch on a paint job multiplied by class action
Yes.
multiples wound up being, what was it, hundreds of millions of dollars? Unfortunately, I wish I could say that this was new and one-off in our legal system. It happens all the time that things that where the literal damages are very small wind up getting blown up through a variety of different bad legal theories into 9-digit things. To that extent, we've already kind of agreed that we'd like to see the numbers cut on appeal. But as far as does it happen or not, but it sure wasn't invented for Trump. It wasn't invented for anyone who in the last 20 or 30 years. The legal system has been doing this. And
In the end, I mean, can we snap out of it for a second? In the end, a guy got a good rate from the bank by telling them that Mar-a-Lago was worth a lot more money. The bank and his apartment was bigger. The bank took absolutely no care about it. They gave him the loan. He paid the loan back, and now they're getting it for $400 million. And this has never happened before. It's never going to happen again. And Letitia James here found this. She said, I want to be clear. White-collar financial fraud is not a victimless crime, James said. When the powerful break the law and take more than their fair share, there are fewer resources available for working people. What does that even mean? There are fewer working people are worse off because Trump. It's such nonsense. But this is the best she can do to defend what she did.
On the one hand, it's political boilerplate. On the other hand, it actually is true that fraud against banks and insurance companies winds up getting taken out in the wash in the form of higher interest rates or higher insurance premiums for everyone. If someone files a bogus insurance claim, yes, everyone's rates go up by a penny or two. And that's I disagree with so much of what she said. I wouldn't pick on that as her worst statement.
Prosecute the fraud that has a victim.
Again, this fraud does have victims, and we just apparently disagree on this. I think that Trump should stop committing so many palpable legal offenses if he doesn't want the law to catch up with him at some point. We haven't talked about the 5 other cases.
Go ahead. I've talked a lot about this. I want to give you a chance to talk about whatever other case that you think is the most interesting to people listening. Go ahead.
No, the most cut and dried is obstruction of justice on the papers he kept from the White House.
Agree.
As we know, a lot of politicians keep those papers. He was the only one who committed obstruction of justice against it. Pretty cut and dried.
I totally agree. I got nothing
with Jean Carroll, and here as an old litigation watcher, I had to just scratch my head because he kept going back and defaming her again. And if he had only left it alone, if he had listened to any lawyer in the world who gave him good advice, he wouldn't have gone back and repeated the defamatory stuff, which was what gave her a big opportunity, because obviously she hates him and could find backing to keep suing him. And he's doing it again. I mean, how crazy can you get? And this gets back into the fact that Trump himself, by being the worst client in the world, which is the lawyer's favorite phrase for him, the one who will never follow the advice that every good lawyer will give him, steps much deeper in these legal situations than if he had been taking good advice and trying to pull back out of the quicksand. Let's leave it with that. I mean, we would not even know Jean Carroll's name if Trump had not made his 4th or 5th or 6th mistake after the original. And of course, we can decide separately about how badly he behaved in the original stuff. But the original stuff would all have been forgotten had he not gotten pugnacious about, I'm going to go on saying that she was lying.
I agree with you. I think the election law violation is utter nonsense. The Stormy Daniels thing. The Stormy Daniels one is, by common consent, the weakest of the ones, and only because New York has this toolkit of incredible weapons for a prosecutor is it going forward. Because if he had done exactly the same thing in many other states, it just wouldn't have been against state law. Can I tell you and everybody how I always and I think this is a pretty powerful argument for people who don't follow it. In the end, the argument in that case is that Trump was supposed to pay Stormy Daniels from campaign contributions. That if he were an honest person, what he would have done was raised money from little old ladies and then taken it to pay off his mistress. That is actually the theory of the case. That this should have been an election expense.
Maybe raised it from RNC donors. I don't know, but the underlying New York law, and again, New York goes way out on a limb in how punitive and stringent it is. But it says you can't falsify records to perpetuate or cover up a crime, and then if crimes are defined very widely, and some of the crimes here, I think genuinely do count as victimless. Not all of them necessarily, but once you've got that thing about if they catch you falsifying the business records to cover your tracks, then they've really got you, and massive penalties kick in. Yeah, that's
no. You forgot. You probably forgot something. No, in New York they have this provision that, and if it's in the furtherance of committing a felony, then it becomes a felony in New York. So they took the federal election law. Which again,
they're also alleging New York felonies.
Right, but it'd be a misdemeanor. That would be a misdemeanor. That would be a misdemeanor.
Bragg is resting it on 2 alleged New York felony charges. Nonetheless, we basically agree on this, this is the weakest of the cases.
And what's the other case?
And then, of course, there's the big one by Jack Smith in Washington, which is obviously over the most serious conduct, and it raises some novel legal issues. I'm not sure we have time to go into all the details.
Well,
which is why
what's your conclusion on it? You think he's there's a good case against him?
I think there's a pretty good case. I'm not sure the plaintiffs, I'm not sure the prosecutors are going to prove every theory. He's got a couple of defenses that he could get some of the counts thrown out on. Now, Georgia today, and we haven't talked about Georgia either, he got 6 counts thrown out in the Georgia case because the prosecution had not done its homework properly, crossing the T's and dotting the I's. They have a chance to go back to the grand jury and get those same 6 counts reinstated. But again, I'll just pass on one bit of information from lawyers, which is you really can tell the difference between federal prosecutors and state prosecutors as far as who is ready for prime time and who can go on stage and not make a slip. In general, the federal prosecutions have been very, very carefully done. And we just saw that the Georgia ones should have looked up Georgia law, and they would have gotten the right kind of count out of the grand jury if they had done their homework.
What do you think about that's why look, a lot of the federal authorities passed on a lot of these cases that the states then took up.
It's interesting. I mean, obviously the federal authorities in the form of Jack Smith wound up not passing. You can argue about whether they should have done it earlier, and you can argue about Smith's decision to let the January 6th committee do its whole thing. That having been said, the interesting omission is they didn't charge Trump with the direct insurrection offenses, and that wound up being important in yet another one that we haven't talked about, which is the efforts to knock him off the ballot.
What did you think of that? What did you think of the Supreme Court decision?
I thought it was inevitable. I had been following that very closely. The interesting thing is that intellectually, there's actually, not bad case. Practically and politically, no, you weren't going to get any of the justices. They made that clear at oral argument, and they split on the rationale. The liberals plus Amy Coney Barrett wanted to decide it narrowly and not decide any issues they didn't have to. The 5-justice majority said, no, let's slam the door, put nails in it, put iron bars on it. States are not going to kick them off the ballot, period, and we don't care what the next fact pattern is. They're not going to. So that's the side that prevailed. But again, intellectually is one thing. In the pinch, when they see potential rioting in the streets, the Supreme Court is not necessarily an intellectual institution.
Well, then I'll let you go after this. So I was on a podcast with Danny Savalos, the MSNBC legal analyst, and they were talking about this case. And at first blush, so I pulled up the amendment, and I hadn't looked into it at all, and I saw that the last line of the amendment was, Congress shall make all laws necessary to enforce.
Not all laws.
Or whatever.
And this was a hinge in the Supreme Court's opinion, because the whole rest of the 14th Amendment, which of course has like 5 clauses or so, Congress does not have to do anything in order to make all the other ones go into effect, but it is authorized to pass legislation if it wants to make sure that it's done effectively. It's an optional congressional enforcement power. And so the Colorado argued it's the same way on this as in the other 4 clauses. But the majority took a different view, which is, no, this one is different, and we're going to read the Lost Clause as being restrictive in a way that we don't read it when it comes to the other parts of the 14th Amendment. Sorry to be so nerdish, but I just had to jump in on that.
Yeah, no, nerdish is good. But so, anyways, I read it out loud. I said, well, it seems to me that this would have to apply in this case. I'll tell you why. And that is in the summary of the opening of that opinion. I didn't read the whole opinion, but I read the summary. Was that because they said Congress has to do this, and the reason was, you kind of alluded to it, that they didn't charge him with insurrection. So what it would amount to is that, let's say they did charge him with insurrection. Let's say Colorado charged him with insurrection, and actually he was acquitted. The logic of the case meant they could still throw him off the ballot because it doesn't matter whether they were charged with insurrection. It's the notion that somebody could lose the right to run for president because lawmakers have decided you've committed a crime without any appeal or due process is so obviously un-American, and so it's absurd.
But you're talking about the Congress being able to do exactly that.
No, Congress could do it
by passing a law saying that such and such a set of facts constitutes insurrection, and thus making clear that Trump could be knocked off the ballot. Again, for the 9 justices that decided, they agreed with a lot of what you said, in that they saw 50 states marching off in different directions, and they said, this is ridiculous. Not only is it chaotic and yielding different answers depending on what state you go to, but the states just intrinsically can't make a single coherent answer the way the federal government could. Now, Congress could give a coherent single answer. What they didn't get to, or at least the majority didn't want them to get to, is what if this had happened in federal court instead of the Colorado Supreme Court? And it went to the Supreme Court itself. Could the Supreme Court itself decide these issues, like whether or not he had committed insurrection or not? And so the Supreme Court, in a way, was taking power out of its own hands. They said, no, federal judges, including us, also should not be deciding this, which was interesting. The 4 dissenters, or not dissenters, but the 4 concurrence with objections, said, wait a minute, it wasn't raised here whether federal judges, who are a different case, have to also be stripped of that power. Let's wait and decide that if it comes up.
I could go either way at certain times, get backed into a corner on originalism versus living document, blah, 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 in the Constitution. But there are certain times when it seems to me that it gets inverted, that the people who would normally vote one way find themselves voting the other way. Obviously, this was meant for the Civil War, when the notion of what an insurrectionist was or wasn't was very obvious. It was just a different time. And now we're bringing it to the front, and now there's this, even to call it an insurrection. But the idea that anything can happen to a person of consequence, that the state can do anything to a person consequential without any hearing or right to appeal.
They gave him a hearing and a right to appeal. Trump had days to argue against the substantive charges, and of course he appealed through the Colorado court system on the issues of Colorado law, and then could appeal to the U.S. Supreme Court on issues of federal law.
No, he
got lots of due process.
He had an opportunity to try the issue of whether he could. They don't even have.
Well, yes, this happened in Colorado court.
So they defined insurrection as a matter of law to him, such that he was able to defend himself against the various counts of the
people. There's some sort of this whole sequence during this case never got as much attention as it should. But yes, there was a whole trial. There were days of testimony on these very issues.
So what's the definition? How do you define insurrection? Do you know?
You'll have to go back and look at the Colorado series of decisions. But yes, they were giving exactly the kind of due process that he would have a right to demand.
In that case, I might be wrong.
All that having been said, the states were the wrong place to do this litigation. Mm-hmm. That's what all 9 justices said, and I don't blame them for that. I think that they also look at this. You mentioned originalism, and I want to get back to that for a moment because the law review articles that developed this case, it fascinatingly were not only written by originalists, but mostly by conservative originalists, who have, like me, have a Federalist Society sort of background. But when I saw all this, I thought of one of the favorite sayings of the late Justice Scalia. I was lucky enough to work for Scalia for early in my career for a year or two. But he described himself as, quote, a faint-hearted originalist. When originalism can be done without making the pillars of the temple fall, without having the building crash down around you, then, yeah, see if you can put in or respect the originalist reading better. But if it's just going to cause the building to collapse on our heads, no, I'm faint-hearted. I'm not going to destroy, big, important institutions of the country just because of it makes for a better originalist reading. That was Scalia's view, and I think ultimately it's all of their view.
People always have to be practical. Do you think they're going to also go unanimously against his immunity claim in September or in March, April?
There's going to be some issues where they're going to get down into disputes. In general, all 9 of them are going to reject his view of immunity, which is basically he gets to do anything he wants anytime. Yeah, that's the easy part. And none of them, even the ones who are most sympathetic to him, are going to go for the full breadth that he's claiming. But they will probably say, and he might get liberals and not just conservatives to say, there are some things presidents do that the courts cannot second guess. And so so when it gets batted back to the lower court, it's probably going to be under some instruction saying, here's some guidance as to whether or not his actions would be within that core immunity, like, does it have to do with pursuing foreign policy or whatever they say. And then the court will compare each of the actions that he's alleged to have taken and say, is that in or out of the line? I think he's by and large not going to come out well in that, but I think that's how it's going to wind up shaking out.
I agree with you. Okay, this is really the last question. If you were Jack Smith, that's his name, Jack Smith, right?
Yeah.
What would be the time? I mean, I'm assuming for the sake of argument that Jack Smith would like to see Trump's election prospects foiled. When would you like to bring this case?
First, it is not a proper motive for
no, it's not proper.
Justice Department. It is obviously against their rule book, which he has been very meticulous about following in the prosecution. All that having been said,
except they suspended the 60-day rule.
Prosecutors have some control over timing. They obviously have control over when to file the charges, and that sets the clock going for the case itself. And we've seen that, big controversy over whether he waited too long on that. It is very common among meticulous federal prosecutors. They take the view, I'm going to nail down the evidence very, very thoroughly before I file the charges, because that's the best way to make sure that everything will stand up, rather than trying to research the case on the fly after it's already up and running with the judge. Do all the research first. And so that having been said, he also has various choices that affect the timing along the way as they do motions practice and so forth. And that turned up in questions of the review of the immunity issues by first the DC Circuit and then the Supreme Court. And it was a tough puzzle to crack. I looked at it and I thought, there are legitimate reasons pointing in every direction. There are legitimate reasons to want the DC Circuit to weigh in. I think Smith wanted to bypass them. But in fact, there were reasons, legitimate reasons, to accept Trump's argument that no, you want the DC Circuit to be able to weigh in traditionally, especially on the most important issues. If you can get the second most respected federal court to say what it thinks is the best view of the thing, then the Supreme Court is less likely to make a mistake than if the Supreme Court had to be deciding the thing for the first time. So yeah, getting their opinion was helpful, and getting the oral argument, the way in which the DC Circuit. So each of these things, as far as and also, should the Supreme Court have just said nope, we're upholding the DC Circuit, and that's that obviously would have sped things up. But again, the Supreme Court might be adding value by refining or even correcting particular ways in which the DC Circuit wasn't 100% on target. I don't blame them for wanting to decide the most important issue they're going to hear in years.
I have. By the way, I knew Tanya Chutkin in my 20s for a very short time, and
cool.
she's very smart. Very. I mean, I don't know if she'd remember me, but I remember her. But anyway, I think it worked out perfectly for them. But as you're talking, I realize the biggest difference between you and me is that I have less faith in people. But I think he's only human. He wants to see Trump's. He wants to see Trump defeated in the election, and this is perfect for him because if the trial had come sooner, and God forbid Trump was acquitted, this could energize Trump going into November. The best thing that could happen is that they present
they're not allowed to take that into account.
I know that. I know.
I'm too trusting.
I just said you have more faith in people than I do,
aren't you?
Yeah. But let me just say, but for them to be able to dump all that evidence in October, if he was really,
you can see that as backfiring against Trump's own tactics of delay, because
yes,
if he had
that's
said,
my point.
I'm innocent and I want a fast trial on this, it would have been over long before October, one way or the other. And let's face it, the issues are not so mysterious that he could not have said, look, it's only going to take my lawyers a month to come up with good arguments on all the issues. Let's have a fast trial.
I think it's a backfire.
He chose delay instead.
I don't know except he might go to jail. I don't know if there's a jail in this. But listen, the reason I don't think you're right is that there was a 60-day rule. They normally don't hold trials 60 days around an election of someone who's running for office. They're suspending it in this case.
What's the actual rule? It's a little bit different from that. But anyway, go ahead.
No, they're suspending it. He's suspending it in this situation.
No, I don't think it's quite that way. But again,
that's what I heard.
We don't have the papers.
Okay.
We can refer them.
That's what I heard. That's what I heard somebody
we'll have
say.
to leave that aside for another day.
Okay, I saw a meme that said that, so I know it must be true.
That's root of all evil is passing memes around. Anyway,
all right. So it's a pleasure.
Thank you for having me on.
No, I cut you off. What'd you say? I'm sorry.
No. It was just a minor thing about timing, but it's better to just say I'm very grateful that you had me on to talk about all this.
It's a pleasure, and let's see what happens. Maybe after all the dust settles, we'll have another session where we can review it all.
Sounds good.
Okay, thank you, sir.
Okay, thanks.
Podcast@comedyseller.com to send us email. Bye, everybody.